Hello, my name is Carl Cicchetti, and I'm Chief Clerk of the Supreme Appellate Court. I'm here today to present the e-briefing rules for appeals filed on or after October 1st, 2021. In July 2021, the State Appellate Court significantly changed the briefing rules that the parties must follow when filing briefs with the Supreme Appellate Courts. This applies to all appeals filed on or after October 1st, 2021. All appeals filed prior to that will use our old rules, but they could participate in an optional briefing program which uses the same rules that went into effect for appeals filed on or after October 1st. All appellate briefs will now be submitted without the Appendix Part 1. The Appendix Part 1 has been replaced by the Clerk Appendix, which our office will produce. When the parties submit their brief and appendix, that's to be submitted as one PDF. And there are significant changes to the format requirements in these briefs. Only 2 paper copies will be submitted using the new briefing rules. If you use the optional briefing program, you will have to submit the required 8 or 12 briefs that are in the rules. All briefs must have hyperlinks to the attached party appendix, and we're switching from page numbers to word counts. So the word count only is for the brief itself. It doesn't count the cover page or the signature or things like that. It's just the brief itself. And then those are all explained in more detail in the rules. So here's a roadmap of what we're doing today. Gave you a little bit of the overview, and different people will present different parts of what is in this presentation. So you can see we'll do the office template, then the e-briefs filed, the petitions for certification, the e-filed appendix using Adobe Acrobat, and then e-filing the brief and appendix.
Hi, this is Claire Kindle, Solicitor General for the state of Connecticut, and I'm going to walk us through the e-filed briefing requirements. We're going to address the cover page, the body of the brief, the hyperlinks and bookmarks, word limitations, certification page. And at the end of this, we'll also talk about the new rules for petitions for cert. So starting off with the cover page. The cover page doesn't change a lot from the old rules, except that on the top, you have to say filed under the electronic briefing rules at the top center. So here in our sample, we have optional, but it's really, this was developed before the rules went into effect. So simply put in a filed under the e-briefing program, and then the normal things you would add to a cover page. The title, name of the court, the docket number, the case number, the nature of the brief, and the name, address, number, and email of who is arguing the appeal. The body of the brief is going to look very different. And this will be probably the biggest adjustment for the brief. We're going to use different fonts. We're no longer using Arial for the new body, for the new briefs. It's going to be Century School Book or New Century School Book 12-point. And the headings are in a different font and a different size. They're in Georgia and they're at 14 points. So taking a look here on the left of the page, you'll see that the headings are bold and in a different font. The margin is 1.5 inches all around. Rather than having justified text, it needs to be left aligned. And the line spacing is neither single nor double. It's 1.3 throughout, including the headings, the block quotes, and the footnotes. And section headings must be marked with letters or numbers. And then also later on, you'll find out they should be bookmarked as well. So it's going to look very different. All of these changes are being done because it's easier to read it online with this kind of spacing, with having an irregular edge on the right, and with having the differences in sizes between the headings and the text. Let's take a moment to talk about footnotes and block quotes because they are going to be the same spacing as your normal text. And so they're going to look kind of strange. So going to the next page, this is what footnotes looked like before. You know, standard single space below the line. Under the new e-filing, This is what they look like now. So there will be a line between the footnotes and your normal text, but it will look like it's pretty much your normal text. And so this is a practice tip that you may want to limit your footnotes and you may want to limit your block quotes because they are going to merge together. Turning now to hyperlinks and bookmarks. Your hyperlink to the appendix you attach to your own brief. So you'll note on the bottom here, this is page 9 of 78. It's not a 78-page brief. It includes page 1 is the cover, and you number it all the way through the end of your appendix. And so your appendix is attached to your brief and filed at the same time. And so your hyperlinks are going to be to the brief that's attached to the appendix that's attached to your brief. So you're not hyperlinking to the clerk's appendix, you're not hyperlinking to your opponent's appendix. And the purpose for this is that the judges, when they're reviewing your brief, can just click on those hyperlinks and immediately go back to the page in your attached appendix where that hyperlink leads them to. In order to know that the hyperlink is there, you should do it in a blue font and you should underline it. Just remember that external hyperlinks are not permitted, but visual aids are permitted, and the briefing guidelines issued by the department, effective October 1, gives a nice list of what kinds of visual aids you can provide. Word limitations. Now, word limitations only apply to the body of the brief. So word limitations are not the cover page or the table of contents or the table of authorities or your appendix that you've attached. They also are not the signature block, certification page, statement of issues, statement of interest, and amicus brief. However, you have, rather than page limits, you now have word limits. And so your appellant or appellee's brief will have 13,500 words, and you can ask for an additional 2,000 words if you need to address a state constitutional claim, or 800 additional words for your reply brief. The combined brief of a cross appellant and appellee is 18,000 words. Combined brief of the cross appellee and appellant's reply brief is 16,000 words. The reply brief is 6,500 words, and the amicus brief is 4,000 words. A little practice tips with respect to dealing with word counts versus page limits. In a word count, make the table of authorities your friend. So do not put in all of the subsequent appellate history or put in multiple reporters, because every single cite will have 4 or 5, 6 extra words to it. And so if you keep your case citations to the primary reporter, the volume and the page and the jump site with a year, and leave all of the extra reporters like the A2 reporters and this petition for cert granted or denied in your table of authorities, you will have plenty of words to make your arguments in your brief. Finally, the certification page, you must include how many words you have done, and there your word processing programs we just highlight from the beginning of the text of your brief, including your headings, to the end of the text of your brief, but not including your signature block. That will give you the number of words, and you need to report that in your certification at the end of the brief. Turning now to petitions and oppositions to certification. This would be a petition for certification from the appellate court to the Connecticut Supreme Court. All of the rules I just told you don't apply to petitions and oppositions to petitions for certification. The old rules apply, so it's Arial 12-point double-spaced text. However, there is a new requirement that you include a brief introduction to provide context for the statement to the questions presented for the review. And so you would put your brief introduction before you presented your questions for review. And with that, I will turn it over to the next speaker. Thank you.
Appendices. There are significant changes to the appendices. In the past, there was the Appendix Part 1, which is now being replaced by the Clerk Appendix, which the clerk's office will prepare. This replaced, for those of you who've done practice for years, this is essentially the yellow covered record that we used to send many years ago. That's now being called the Clerk Appendix. There is no more Part 1 and Part 2, but what there is the parties now have the party appendix. So if something's not included in the Clerk Appendix, the parties can still add things to their brief and appendix, but it should not be duplicative of what is in the Clerk Appendix. And then there are formatting requirements for this that are in Practice Book Section 67-2A. It's important, really, really important to check out the rules. And I also want to point out that in the current practice book, the 2022 version, there's different rules for appeals filed before October 1st, 2021 and after. So make sure you're looking at the right section. One of the things that we've encountered is that people are conflating both sets of rules. So they'll change the font to Century School Book, but they'll still have the old formatting requirements for the brief. So it's important that you look at the rules for when your appeal is filed and file the brief according to those rules and those formatting requirements. Please, please, please do not conflate the rules, because it'll just end up with your brief being returned because it won't meet either requirement, the ones for prior to October 1st and the ones after. So here's an overview of the clerk's appendix. This is going to be prepared by the clerk's office. And then this is going to be done by reviewing the case file and the preliminary papers that are submitted. So it's important, really, really important that you provide the clerk's office with a detailed list of pleadings that should be included in the appendix. It's important not to be over-inclusive, because if you list everything that's in the trial court file, that's not really helpful to the clerk's office. And then we're going to base what we do based on the preliminary statement of issues, the appeal form. So it's most helpful if you provide us with really good information. Some of the main things that it should contain are the decision being appealed, the pleadings, motions, orders, and other documents that are relevant to the case. But we're not going to include memorandum of law. That's pretty clear in the rules, and you know, it's important that you recognize that we won't be including those. There are some instances where if there's a short motion, there could be a little bit of argument in there, and there's some flexibility, but as a general rule, we will not be including these. So if it's important to have them, you may want to include that in your party appendix. Also, we'll reach out to you, or we can, if we have questions. I know that in some of the clerk appendices that I've done, I've reached out to counsel, because at the end of the day, the counsel is going to know their case best. So if someone does reach out to you from our office, please make sure you talk to them, because we ultimately want to give the court the best product, and that's achieved when the clerk's office and the parties work together. Officers' returns, transcripts, and exhibits shall not be included unless they had been annexed to a document, docketed in the case. So basically, we're not going to include a lot of attachments to motions. We don't want to have a 600-page document in there. Well, you know, we're electronic now, so it's a little easier to manage than a giant book of paper. We still want to make sure that this is a streamlined thing for the court to look at. Judgment files are no longer included in the amended rules. So if you don't need to worry about those being in the clerk appendix, but it's important that you work with the trial court to make sure a judgment file is produced so this court can look at it if they need to. So I mentioned this before, the appellant must file the designation of contents within 10 days along with all other preliminary papers. This is the most important document for us when we're preparing the clerk appendix. You're going to know your case better than us, so you need to tell us what you think are the most important things to go in there. Now, it's not just because you put it on your designation doesn't necessarily mean that it will be in the clerk appendix, but please makes both of our lives easier if you do this and you do it well. And then the opposing side, they have within 7 days, they might file their own designation for the clerk appendix. And again, this is important too. We want to hear from both parties when we're putting together the clerk appendix. Ultimately, the final decision is with the clerk's office, what goes in the clerk appendix, but we want to work with you to produce the best product. If we don't include something in the appendix that you think is important to have in the appendix, you are free to put it in your party appendix with some limitations. Of course, you can put whatever you want from the court file in there, and it should not be a problem. There are exceptions for admin appeals, and I don't want to get too involved in those because the admin appeals are, some of them go to the trial court first, and then we get them. So I don't want you to worry about that too much. But part of the return of the administrative agency papers that we're going to include in these are the application or appeal to the agency. We want to know how it got to the agency. We want to know the notice of hearing, what the agency did. And then the decision. We need to know what the agency decided. And then if there are other relevant portions to that, we would include it as well. And then the other portions of the returned agency record needed for proper presentation of the issues. So, if there's a motion to correct or things like that, those are things you might want to designate for us to include. And it's important that these are filed with these are typically filed as the return of record in the trial court. We will get the documents from there.
Hello, I'm Jeffrey Babin with Wigan and Dana in New Haven. I'm in the appellate practice group, and I am here today to talk about the party appendix as part of the new E-Brief appellate rules. The party appendix is addressed in section 67-8 of the revised practice book. These are the rules that were originally published in the July 13th, 2021 Connecticut Law Journal, which can be Googled and found online, since the Connecticut Law Journal is now posted by the Judicial Branch. Prior to this, you've just seen about the Clerk's Appendix. The Clerk's Appendix and the Party Appendix work hand in hand. And so it's useful to, again, refer to what's in the Clerk's Appendix to understand what's going to be in the Party Appendix. These roughly correspond to the previous rules for those who've been practicing for a while in Connecticut, to the Part 1 Appendix, which is roughly equivalent to what is now the Clerk Appendix, and what used to be referred to as the Part 2 Appendix, which is essentially what is now going to be the Party Appendix. And of course, the Clerk Appendix is something that the clerk's office will be compiling and uploading onto the docket sheet, and the Party Appendix is going to be the party's responsibility and filed with your party brief. And the thing to also remember is that while you're going to have some influence over what's in the Clerk's Appendix through the designation that you make under Practice Book 63-4, ultimately the clerk will decide what is in the Clerk's Appendix, but whatever is not in the Clerk's Appendix is something that you can then add to the Party Appendix. It is your appendix to present to the court to supplement your brief and allow the court and the appellate judges to have at hand the things that will best explain to them what your argument is about, what the record is that supports your argument. There's virtually nothing that's actually required in the Party Appendix. The one thing that is required is citing to any opinion that is not officially published. So, for example, a case that is found, for example, only on Westlaw or Lexis, that for now still has to be in your Party Appendix. If the Connecticut Supreme Court or Appellate Court has issued something, an opinion, as a slip opinion, and so it's not yet in the Connecticut Law Journal. It doesn't have a con or ConApp site. That is still an officially published decision. It may not have a citation and does not have to be in your party appendix. You can simply refer to the slip opinion by court, by the case name and by the date. To better understand, again, what goes in the party appendix, let's just take a quick recap of what's going to be in the clerk's appendix. And when you file your designation in the clerk's appendix, you may actually want to, if it's a little unclear why you're designating something, you could even annotate it and explain to the clerk why you want it in the clerk appendix, why they think it's relevant. But essentially, right, it's the trial court docket sheet in the clerk appendix, the operative complaint, any of the decisions that are being appealed, and the appeal form, the notice of appeal. Anything else can go in the party appendix, and you have the ability to therefore shape the record that the court sees. One thing, though, is you do not want to overburden your party appendix. It is best to limit the contents to really what you want the judges to actually turn the book open to, your book, meaning your appendix, to have handy for them to understand. If you overload it, there's a couple of problems. One, it becomes unwieldy. They're not going to just read through your appendix just for fun, for things that you're not citing. And there's a problem with file size, ultimately, because under the new rules, your party appendix is going to be one PDF with your brief. It's going to be a single PDF, and there's ultimately a megabyte file size that you don't want to exceed. So, and of course, you also have to still file 2 copies of your party appendix, paper copies, in addition to uploading it. So best not to put in things that you don't need. And what are the kinds of things that you might want to include? You can have, for example, trial court exhibits, exhibits that were identified and marked in court at a court hearing, any exhibits that are needed, as well as court transcripts from any evidentiary hearing, any relevant oral arguments that were made in the trial court. And the key, of course, is to only include excerpts. The rules greatly dissuade you from putting in entire transcripts. Sometimes if it's a very lengthy exhibit, you don't even need the entire exhibit. Put in only what is needed to make your appendix more usable and user-friendly. And any other items necessary to present the issues on appeal. Very little, again, is required, but there are rules if you go through the practice book that say, for example, if you're challenging the exclusion of evidence at trial, you're going to want to include where that took place in the transcript, where evidence was offered, where an objection was made, any argument on the objection, and the trial court's ruling sustaining or overruling the objection to evidence. The same thing with jury instructions, for example. If you're challenging that, you're going to need to include what the jury instructions at issue on your appeal, and probably also where that objection may have been preserved in the transcript. Another thing to think about is that if something is not in the clerk appendix, but is at issue, for example, not just the operative complaint, which might be in the clerk appendix, but an earlier complaint, if there is an appellate issue that might rely on that earlier complaint, hopefully any decisions by the trial court that are directly being appealed are in the clerk appendix. If something was left out, you can put it in the party appendix, but sometimes there may be other trial court rulings that are pertinent to the appellate issues, are not necessarily the the decisions that are being appealed. And of course, you can then include those in your party appendix. The other thing that may be useful and actually is referenced in the rules for your party appendix are any pertinent statutes or regulations that you rely on. Not peripheral statutes, but things that are directly at issue where the court is going to want to actually reference that statute or regulation. It may be particularly useful if it's a statute or regulation from another state. The other thing is what's important is that you're going to have a table of contents for your party appendix, and that's important for the court to be able to navigate, particularly with exhibits. It's important if you're citing to, for example, Exhibit 2 in the table of contents to your appendix, you're going to want to put in a short description of what that exhibit is. Maybe it's, contract with party X or medical report of Dr. Y, so that the table of contents is more usable. And that's also important because under the new rules, you are going to have to bookmark your appendix. You have to bookmark, in fact, the brief and appendix. And bookmarks are a PDF feature. When you create the final PDF, there is a place in the PDF file on the left side where you click and you can see the bookmarks, which allow the judges to navigate through the brief and appendix, through the brief and a party appendix. And those bookmarks will allow them to then see the different appendix items and be able to easily navigate to those. And so you're going to want a description, but you don't want too long of a description, just like you don't want headings in your brief to be too long. And not only is it because it's just not user-friendly for it to be too long, but it could overwhelm the bookmarks, and they need to be visible in a window for the judges to see. And it's also important to remember that you're going to have to hyperlink two items in your appendix. So again, the brief and the party appendix are going to be a single PDF document. And it's going to be consecutively numbered, which may seem counterintuitive. From the cover of the brief, which is page 1, the table of contents of the brief, and then the body of the brief. And then you're going to have the cover of the appendix and the table of contents to the appendix, and then your appendix. And we do not start again with page 1. In fact, the cover to your appendix is going to start off with a page number that follows the last page of your brief, which is probably your certification page. And then the table of contents will continue from there and through the pages of your appendix. So it's one document, and you're going to have to, within your brief, hyperlink to any citation to the appendix, which again is going to be part of the same PDF document using PDF software. This is not a technical presentation, so I'm not going to refer here to the technical aspects of using your PDF software, but that is critical. Your brief is going to hyperlink only to the party appendix and not to other documents that are not part of the same PDF document, like the clerk appendix, or for example, when you're doing your reply brief, unless you do a supplemental party appendix, which is not referenced in the rules, but should be permissible. If you're referring back to the original party appendix with your opening brief, you will not be able to hyperlink because it's not part of the same PDF document. Okay. Again, you don't want to overload the appendix, require more hyperlinking. It's going to have a large file size. One thing to remember is that with your PDF software, you can frequently optimize the file size of your combined PDF of your brief and party appendix. I have PDF software that that we use for this purpose is usually an optimized command, especially if you have any color documents in your appendix that can be quite unwieldy. In terms of file size, if you run it through an optimized program in your PDF command, you can often slim that down, make it easier for the judges when they are working with the document to open it and navigate through it, and make it easier to upload it at the time you file your brief. One thing to also remember is that when you are thinking of the contents for your party appendix, to not include trial court briefs. The court does not want to see the trial court memoranda of law or the trial court briefs. They have word limits for the size of the appellate briefs. We used to have page limits. Now we're going to have word limits for you to make your presentation. They may want to see, the trial court motion, which will be in the clerk appendix, but they do not want to see the trial court briefs. However, it is possible, if there is independent legal significance to a trial court memorandum of law or brief, to include it, but you're going to only want to include excerpts. We talked earlier about excerpts for transcripts or exhibits. It's the same with a trial court brief. And why would you include any part of a trial court brief in your party appendix? It would be, for example, if there's a question of waiver on appeal. You want to show that the other side waived, or the other side accuses you of waiving an issue and you want to show that it was in fact raised in the trial court. The flip side of that is preservation of an issue. You want to show that you preserved an issue where there's a question about it, and you may want to put in an excerpt from a trial court brief to show where you preserved an issue. Again, reproducing a full document when only an excerpt would suffice would be a misuse of the appendix. I want to just turn back again to the transcripts. When you include a transcript, an excerpt of a transcript in your party appendix, the court does want you to at least include the cover page that shows the date of the transcript and the certification page that shows that the court reporter certified the transcript as a complete and proper transcript. So in between that cover and that certification page, you will include the excerpts of the relevant transcript pages from that date. I hope this has been a helpful presentation for you to understand the new party appendix. Again, it's similar to the old part 2. There's just technical aspects of it now that are somewhat different because of having to be bound in with the brief, hyperlinks in your brief, and the pagination being consecutive, which is also a good reason why you really need to finish your party appendix and understand what's going to be in it at least a day, probably at least 2 days before the deadline for your brief, because of the need to then finalize a PDF, have it all properly numbered so you know, because when you change the pagination of your brief, it's going to change the pagination of your appendix. So then you can put in the correct citations to your appendix, do the hyperlinks, do the table of contents. There's a lot of moving parts. It's somewhat circular. And so this system is going to require you to really have your appendix and brief done in advance of the due date and not at the last minute. So with that, I thank you for your time.
So some important resources for everyone to consider: the practice book. That's, I look at the practice book every day, and I would encourage anyone who's doing appellate work to do so. The rules, we try to make them clearer and clearer every year. I think they're really helpful when submitting documents to the court. Judicial Branch Guide to Creating Electronic Briefs. We have a self-help page, the appellate court, and there is a lot of information on there that I think is really helpful to the parties. There's sample documents, not just for e-briefs, but everything. We have e-brief guidelines. We have the e-briefing checklist. So this is what we look at when we take in the e-brief. So it's, if you look at that you'll look to see what we're looking for. It's basically a Cliff Note version of the rules. And then there's the Judicial Branch references Supreme and Appellate Court practice. Again, that's on the self-help portion of our website, and it's an invaluable resource to anyone practicing in the Appellate or Supreme Court. And if those documents aren't helpful, please give us a call. It's part of our job to help. We want to make sure that the parties are filing compliant documents and that we're getting the best product to the court. So if you have questions, please do not hesitate to call, and we are happy to serve the parties and the court. And thank everyone for listening to this, and if you have any questions, you can give me a call personally. Have a good day.